Hello, Your Honour. My name is Michael, and I am the defence counsel for Simon in the criminal proceedings today. I would like to start today by making a submission to the court that the record of interview to be inadmissible evidence as under Section 130 of the Queensland Evidence Act. This is based on discretionary exclusion. This is based on two breaches of the Police Powers and Responsibilities Act. The first one comes from Section 403 and the second one comes from Section 420. I'll start by talking about Section 403, and that's the initial period of detention for investigation or questioning by police. So subsection 1 states that an officer may detain a person for a reasonable time to investigate or question a person about an indictable offence. Subsection 2 states, however, the person must not be detained for more than a period of 8 hours, unless the detention period is extended under this division. As per the facts, the detention period was not extended, and the detention period commences as under subsection 5A when the person is arrested for an indictable offence. And so we have here, based on the facts, someone was arrested at 10 a.m. For an indictable offence, being the murder charge, and formally charged with murder at 7:05 p.m. This is a 9 hours and 5 minute gap, and police have therefore breached the time limit by an hour and 5 minutes. Your Honour, I would like to bring to your attention a breach by police of Section 420 of the Police Powers and Responsibilities Act. In subsection 1B, it states the police officer must reasonably suspect the person is an adult Aborigine, or in this case, over the age of 16. Based on the facts and establishing that Section 420 applies to Simon as he is under the age of 16, the police reasonably believed that Simon was over the age of 16 because instead of making in contact or getting into contact with his support person, they notified or allegedly notified legal aid. So if they are operating from Section 421, subsection 2A, they would have contacted his support person or his mother, straight off the bat. But they didn't. They contacted the Aboriginal and Torres Strait Islander Legal Service, allegedly. Subsection 2A states a police officer must inform the accused that representation from a legal aid organisation will be notified. And subsection 2B states that this should be done as soon as reasonably practicable. So police are to notify or attempt to notify. Based on the facts, there is no record of a call ever being made to legal aid or the Aboriginal and Torres Strait Islander Legal Service. In this situation, the police did not follow due process. Police also did not follow due process in the case of Bunning and Cross. The police did not follow due process in the case of Bunning and Cross, and the High Court deemed that the evidence supplied by police in that case was inadmissible. And that's due to the fact that police didn't follow due process. What we have in this case is police also not following due process, breaching not one, but two of the sections in the Police Powers and Responsibilities Act, and as a result, this has led to the attainment of this evidence or the record of interview made by police. As a matter of public interest, in the case of Bunning and Cross, the High Court stated that the evidence is inadmissible. In this case, in the same way as a matter of public interest discretion, I'm submitting that this evidence should be inadmissible. So, Your Honour, as I was saying before, as a matter of discretion and as a matter of fairness within our society, and the power of the court to exclude evidence, it is my submission that as per section 130 of the Queensland Evidence Act, that the record of interview be deemed as inadmissible evidence in this trial, so that this trial can go forward for Simon within a fair process. Thank you, Your Honour.